Up next, we have House File 2704, Representative Perez Vega. I'll note that we did hear this committee did hear this bill last year, although we didn't move it, and so we're glad to hear it again this year. Representative Perez Vega, would you like to move your bill?
I would like to move House File 2704.
Representative Perez Vega moves that House File 2704 be recommended to be referred to the Judiciary, Finance, and Civil Law Committee. And Representative Perez Vega, I understand you have an author's amendment.
I do have an author's amendment.
Would you like to move your amendment?
Yes.
And then briefly describe it, please.
The amendment is to insert tenants association using the right provided in this chapter, the language adopted by laws and operating agreement related to the internal governance of the tenant association. It's and to also delete page 2, line 17, and insert section C, a tenant association must be completely independent of owners, management, and their representatives.
Any questions on the A3? If not, we'll vote on the A3 to get the bill in the shape you prefer. All those in favor of the A3 say aye. Aye. Opposed? The A3 is adopted. Representative Perez Vega, to your bill.
Thank you, Chair and members of this wonderful committee. Representative Perez Vega would like to reintroduce House File 2704, Tenant Rights to Organize, which is designed to ensure tenants can organize their buildings around living conditions without fear of retaliation or displacement. This policy is designed to protect Minnesota renters from predatory landlords who intimidate and retaliate against renters for participating in tenant organizing activity. This bill allows tenants to do going door to door to offer information or on interest in joining a tenants association, using common space or meeting facilities to discuss living conditions, meeting without representatives or employees of the owner or management company that's present, receiving organizing assistance from non-resident tenant advocates, initiating contact with tenants via mail, phone, or electronically, and assist tenants in participating in tenant association activities. Tenants' rights to organize have been successful in Minnesota and other jurisdictions. Minnesota Statute Chapter 327C, covering manufactured home park rentals. The law protects organizing and outreach activities in manufactured home parks, supporting residents' ability to form associations and advocate collectively for improvements to their property. California, New York, the District of Columbia, and numerous cities across the country explicitly protect tenants' rights to organize. 35 states have adopted a short provision from the Uniform Residential Landlord and Tenant Act, or a comparable provision which bars landlords from retaliating against tenants for participating in a tenant union. This bill does not create an obligation for landlords to share tenant contact information, and legislation does not interfere with no solicitation provisions because it's for non-commercial purposes. The imbalance of power between landlords and tenants have a catastrophic impact on vulnerable Minnesotans who have lack of resources to fight back versus unjust lease requirements and uninhabitable living conditions, and that's why I'm so passionate to present this HF 2704 today.
Thank you, Representative Perez Vega. We'll move to testifiers, and first we have Margaret Kaplan with the Housing Justice Center. Welcome to the committee.
Thank you, Chair Howard, members of the committee. My name is Margaret Kaplan, and I am an attorney with the Housing Justice Center, and I'm also the president of the Housing Justice Center. We focus on the right to safe, stable, affordable housing free from discriminatory barriers. The tenant right to organize is a really important issue for us because so often people don't have access to the rights that they should under the law. And a lot of the time it's because they don't know about them. And they don't know about the shared experience with their neighbors. Or if they want to raise issues and concerns in their rental housing, they face threats of eviction, rent increases, changes of rules, lack of maintenance of their property. So I just wanted to walk really quickly through the bill. It's a pretty short bill. Really, the first section and the second section are definitions. So what do we mean by tenant association? What do we mean by tenant organizer? And in this case, a tenant association is people who have the same landlord working together to address issues related to community life, amenities, housing condition. The second section is the definition of tenant organizer. So that's a tenant or somebody who's a non-tenant assistant who's helping people organize a tenant association. So helping people access their rights and work together. And then the third section really goes into what are those activities that count as a tenant right to organize. Note that this doesn't create any obligation for the landlord to do anything in particular with regards to what tenants are organizing about. It doesn't require a landlord to distribute leaflets, provide private information, anything like that. It's just saying that they cannot interfere with tenants who are organizing together to work for the common good of the community. And finally, I want to point out section 2, which is the section on retaliation. This is simply saying that if you are trying to exercise your rights under the law, you can't retaliate it against. You can't be evicted for talking to your neighbor. And one of the things that we've seen in a lack of a tenant right to organize is communities where people are receiving violation notices just for knocking on their neighbor's door. Right? And so we want to avoid that kind of activity. We want to make sure that people can assert their rights without interference. And then finally, subdivision 3 actually gives meaning to the law by saying that not only is this a right on paper, but there are actual penalties for violating it, which is one of the things that is a real challenge. If you have rights but you can't assert them, they don't mean too much. One of the things that I just want to point out here, once again, is this isn't really requiring the landlord to do much different than what they already do. It is not solicitation. It does not violate people's right to quiet enjoyment. Also, it does not constitute taking under Cedar Point Nursery because tenants also have property rights, and that was a very narrow holding that specifically distinguished the Yee case, which provides tenant rights. And so we really think this is an important issue, and happy to answer any questions about it after the other testifiers.
Up next, we have Marion Butler. Welcome to the committee.
Hi. Hello, thank you, Chair Howard, Vice Chair. I don't know how to pronounce your name, I'm so sorry. Abaje?
Yes, there you go.
Okay. Minority Lead Johnson and members of the committee. My name is Marion. I am a tenant at Ridgebrook Apartments. I have lived at Ridgebrook Apartments for 2.5 years. I am here to speak in favor of Tenants' Right to Organize Bill number HF 2704. I would say starting of November, I've been organizing tenants against the injustice and the neglect on management part to its tenants, and recently I've been retaliated against. In the past 2 years, I've been having pest issues, maintenance issues, mold, water damage, cabinets needing to be replaced, security to my back door was not secure. I've had to reach out to the City of Brooklyn Park Inspection, making complaints so that the repairs in my apartment could finally get done. After me doing that, it took a month for them to finally complete everything that needed to be repaired in my apartment, and then went on to speak at city council meetings. Addressing the issues that tenants are going through, and after doing these things, I have been retaliated against. The management at Ridgebrook Apartments have given out lease violations through pest control companies by calling my apartment unsanitary. And it is retaliation because we are being charged a $300 lease violation. I've spoken with my lawyer, and nowhere in my lease does it say anything about lease violations for unsanitary conditions, and more importantly, what fees are charged in accordance to these violations. The fee recently went up from $300 to $350, so it's very unfair that all of this is going on. We are trying to hold them accountable for the things that we've been going through, and in turn, they are retaliating and using unethical tactics. And I'm not alone. The retaliation is happening to my neighbors who have raised their voice as well. There's an ongoing pest issue that doesn't look like it's ever going to be resolved. So we're asking for this right to organize a bill to be passed. Going through injustice, neglect, having to endure the things that myself as a tenant at Ridgebrook have been forced to deal with is unbearable. We pay money to live there, but we have no power at all as tenants. We're expected to stay silent regardless of our housing conditions, and that is not fair or right. It's important that the state supports tenants to have the right to organize without retaliation upon raising our voice. I hope you take me and my neighbors' concerns into consideration. I hope you ensure this bill for tenants' rights to organize is passed so that tenants across the state are able to advocate for their family without negative consequences. Thank you all in advance.
Thank you for your testimony. Next, we have Jafar Aliweed. Welcome to the committee.
Thank you. Hello, and thank you, Chair Howard, Vice Chair Agbaje, and members of the Housing Committee. My name is Jack Farr, and I'm working with the New American Development Center. We are a nonprofit organization for immigrants and low-income members of the Somali and East African communities. As a nonprofit, and that is working with the undeserved community, we have tenants contacting us to speak on their behalf to their landlords. Some of the landlords are hostile towards us and their tenants, and they don't give us the chance to mediate between the landlords and the tenants. Some of the complaints the tenants have are the landlords are charging additional fees, low to no maintenance of their units, restricting their kids to play outside, and many more action against the tenants. Some of the tenants had stubs that weren't working, and they were forced to buy meals outside instead of cooking for their families. One of their landlords told us that they can't repair stubs because your people like to cook a lot, meaning the Somali community. We believe House File 2704 will give the tenants security and power to advocate for themselves without fear of retaliation, and we urge you to support House File 2704. Thank you.
Thank you for your testimony. Next, we have Jennifer Gordon. Welcome to the committee.
Thank you. Can you hear me okay?
Yes, we can hear you.
Mr. Chair and members of the committee, thank you for allowing me to speak this afternoon. My name is Jennifer Gordon. I've worked in the rental industry for over 25 years. I currently oversee about 12,000 units in the Twin Cities. And I'm here today on behalf of my role as current board vice chair of Minnesota Multi-Housing Association to state our concerns with House File 2704, the right to organize tenants. We agree tenants should have the right to associate with one another, to discuss their housing conditions. Residents should be allowed to address concerns related to their housing. However, this proposal goes farther than that. As written, the bill permits unrecognized individuals to gain access to a secured building for a purpose as ambiguous as community development. These individuals are not required to meet any background check requirements, which is a concern for those accessing an otherwise secured space. The permitted activities described under subdivision 1A are concerning, as some of these activities go against the terms of the residential lease and potentially violate the privacy of other residents in the building. Line 212 would permit a tenant association or organizer to contact other residents through mail, phone, or electronically. Is the landlord required to provide this information to the tenant association or organizer under this proposal? The activities protected under subdivision 1C may be considered disruptive by some residents, and the ability to remedy this situation is unclear. Additionally, it's important to note not all properties are built the same and not all are conducive to group gatherings. Yet subdivision 1C does not allow landlords to prohibit protesting or group assembly, even when it jeopardizes proper ingress or egress. Lines 2.23 through 2.26 state that a housing provider cannot require someone to obtain permission to engage in activities on the property. But then the next sentence provides we can enforce limits in time, place, and manner. This language is confusing and needs to be revised for clarity as to the intentions. Also, we believe the new retaliation language is unnecessary as protections are already provided in statute. Thank you again, Mr. Chair and members of the committee, for your opportunity to share concerns with this proposal. I appreciate it.
Thank you for your testimony. Our last testifier is Catherine Banbury with Homeline. Welcome to the committee.
Thank you. Good afternoon, Chair Howard, members of the committee. My name is Catherine Banbury. I've been a tenant in St. Paul for decades. I'm also a tenant organizer at Homeline and a member of Equity in Place. I want to thank Representative Perez Vega for championing House File 2704. And I'm speaking personally today to why I am in support of the Right to Organize bill. Listening to my neighbors' constant despair, desperation, and anguish at trying and failing to negotiate rent increases on their own that in some cases have ended in eviction, and in many cases ended in them being economically displaced with nowhere to go, is actually what propelled my decision to become a full-time tenant organizer with Homeline. This past year, Homeline has multiculturally organized and played a role in mobilizing hundreds of fellow tenants across the city to elevate our shared experiences in our rental properties. Because of these successes, corporate management swiftly responded with increased restrictions on the freedoms and rights of renters to organize. This included clearly defined legal threats to myself. For instance, after flyering and door knocking resulted in 25 to 30 tenants regularly attending monthly meetings at my building, management cracked down, restricting promotion of the meeting to a single flyer in the corner of the mailroom. I myself was penalized with strikes on my record, communicated to me through their lawyer, threatening eviction to me and my family with even a single additional act of unsanctioned outreach. Today, most tenants in my building are afraid of retaliation because they see what is happening to me. The association meetings have significantly dwindled in size and scope. This fact is incredibly discouraging to me. The anxiety and unease that this retaliation has caused within myself cannot be underestimated. As a tenant, along with all the tenants I work with and the tenants I haven't yet met because of their fear to freely assemble and work together, we urge you to vote yes on House File 2704.
Thank you. Is there anyone else in the audience who wishes to testify? If not, we can go to member questions. Representative Nash.
Thank you, Mr. Chair. And I'm trying to remember back to when we did this last year. There, I think, was some concern from our side of the table as to the level of access that organizers might have, and were those folks being scrutinized prior to entry into the building, just as a precautionary effort to make sure that maybe there's a background check done on them or something along those lines, because I don't know what the process is and would love to know, but is there access, and maybe this is for the author, is there an effort that would be undertaken to make sure that the person who would be an organizer has been run through a background check to make sure that they're not a prohibited person, or they're not a dangerous person, or something along those lines? Because if this is to become law, and we want good people to be entered into a building if that's going to be the case, but we often know that some folks do things to have a surreptitious entry into another area. So just wondering if that's something that exists or maybe could exist.
Representative Perez Vega or Ms. Kaplan?
Thank you, Mr. Chair and Representative Nash. As someone that lives in a residential building and has had several conversations with folks in regards to what this would look like, I think about every time I let a guest inside of my place, and they don't need a background check to be allowed into that building. And if anything was to occur where me not knowing their background check happened, I would be held accountable by the premises of the building as to allowing someone in there. I would like to ask you to answer and respond if you have any additional, but as far as a background check on anyone that is invited to participate, whether it is to discuss what we've heard from our testimonial today, and from pest control all the way to maybe a makeup party in your party room, I would have to say that's quite a bit insulting to say we need a background check on someone who is going to be of an advocacy of a concern or of a supporter for consumers.
Ms. Kaplan?
Yeah, I think that, thank you, Mr. Chair, and Representative Nash, for the question. I think it's a really important one. A couple of things that I think are important to note. The first is, as Representative Perez Vega noted, people have a right to have guests, and those guests don't need background checks. And so that seems like it could be a little bit overly intrusive then. The second thing I would note is that organizations that do tenant organizing, we are really careful about employing people and making sure we do background checks on them as well too. If somebody is on the premises for bad purposes, then the landlord has every right to remove them from the property if they are engaged in something illegal. And we see that happen occasionally in all kinds of properties, right, where somebody engages in illegal activity, and that becomes a real management concern, and management sort of being on top of those issues and making sure they're addressing people's right to quiet and enjoyment of their properties. Really important consideration. Another thing I would note, though, just in terms of people feeling safe in their properties, is you feel safer when you know your neighbors. Right. Creating community and creating space with other people in your building kind of allows you to understand who's there and who isn't, and who's supposed to be there and who isn't. And it feels safer in a way that I think people operating in isolation rarely feel.
Representative Nash?
Thank you, Mr. Chair. And so I just want to make sure I heard you correctly. When you look to hire someone who might be an organizer, you do a background check on them? Is that a legal requirement, or is that a procedure that you at your organization do on your own?
Ms. Kaplan?
Thank you, Chair Howard, Representative Nash. That's just a best practice in employment law. There's no specific legal requirement for that, just as there's no specific legal requirement for background checks by property owners or landlords for the person who's going to come in and fix the toilet, right? This is, to a certain extent, I think we have to make sure that we're really thinking about access as something that is, and the ability to offer access to a property is something that is owned by the tenant who has property rights in that property. And so if they're granting somebody permission to come and, do some tenant organizing, having that higher barrier just seems like it's a little bit of an overstretch.
Yeah.
Representative Nash?
Thank you, Mr. Chair. And maybe if you wanted to come by my office, I have more questions, and I don't want to belabor this, and I'm not.
Sure.
I'm not trying to castigate anybody. I'm just trying to say if a person is to have access to the building, and I think I remember asking last year, the folks that may be coming in to organize aren't always known personally by the person that is inviting them. Mm-hmm. So that extra layer of potential scrutiny might actually be a good thing in the grander picture of things. So I would love to talk more about that.
Representative Kozlowski?
Thank you, Chair Howard, and Rep for bringing this bill forward. I spent most of the entire summer and into the fall, actually reviving our Duluth Tenant Housing Union. And I think, as we've heard in this committee, that so long as we have a commodified housing market, the number I think was 95% of Minnesota housing stock is privatized. And I think we've made some really great efforts to move towards, cooperatives, to guaranteed housing for all. I personally, gonna just be honest, I would love to see us continue to commodify, move to social housing, but until that point, I think as long as we're calling somebody a lord, says we got a long way to go. I don't know, that feels like it for me. But I just wanted to chime in that, we have a lot of renters in my community. It's over half of us, and a lot of those are Black, Brown, Indigenous, poor folks, caregivers, single parents, folks with disabilities, and we knocked thousands of doors in my community. And what we did was we actually started meeting, and we had about 30 people. They come, you eat a meal together, you talk about here's your rights, you talk about here's my story, the rent is too damn high, right? You're sharing community and collective power and knowledge and equipping people, and sometimes there's language barriers, and so people don't always understand, or they're disenfranchised, or we've got lack of trust in the government, and all of these different barriers. I heard stories from college students to elders who told me things like there was unexpected fees, $25, $50, when they went to go do the application to reapply for their house. And they said, well, I'm not going anywhere. Why would I have to pay that fee? To things like rodents. And we've taken those measures with the tenant protections bills last year, but we know that there's still that imbalance of power. And so I just wanted to chime in and say that I think it's a really beautiful thing that we have people from all across our communities who want to be a part of our housing crisis and solutions, and that the people closest to the problem should be closest to the solution. And, the other thing, I want to just make sure that in this bill, under residential tenant, does that include like mobile home parks, for-profit and nonprofit, right? It's any renter?
Representative Perez Vega.
Thank someone. I love music, by the way. So
Sorry about that.
but fortunately, we don't have a soundtrack in here. Thank you, Mr. Chair. Can you, as far as the mobile homes?
Yeah, it includes any residential.
Correct.
Okay.
And as I stated when I introduced the 2704, is that the Minnesota Statute Chapter 327 covers manufacturing on home parks, and mobile homes are part of that.
Okay.
Representative Kozlowski?
Well, yeah, and then one more question. So in terms of, living in a community where everybody knows everybody in greater Minnesota, I swear. And so to the retaliation piece, I really appreciate that we spent a lot of time on that, because that's something that we think about a lot, and that hasn't come to fruition yet where I'm at. But as we've heard, it has in other parts of the states when people come together and start organizing in this way. And so I'm just curious if you could walk us through or help us better understand what that process would be like if there were retaliation. Would that go through the courts, or is there organizations that could help a tenant in the event that they are retaliated against? Because what I was thinking is that this could be, potential on-ramp for us into the foster care system and those things that we see with CPS or with law enforcement. And so making sure that, because we're fighting for our rights and we're fighting to make sure that we can afford our lives, that doesn't fall back on us. But we know that our communities face a lot of barriers that when it does, it can be hard to take action. So anything that you'd have about that process would be greatly appreciated.
Representative Perez Vega or Ms. Kaplan?
Let you respond on that one.
Thank you, Mr. Chair, Representative Kozlowski. So in terms of the process, it does a couple of things. I mean, one is if you have a right and you know about it, right? If you've experienced retaliation and you know about it, it really empowers people then to be able to bring that to the attention of their landlord, right? Like, you cannot do this because I have these rights and I did these things and this is protected activity and what you're doing is retaliation. And a lot of the time, especially if it's not done in bad faith, folks are like, oh, I didn't know that, right? And they'll back down, hopefully, right? Assuming best intentions. But if somebody really wants to retaliate against somebody, what this does is it really opens the door for private cause of action. It kind of semi already exists, but it says, like, in this instance, not only do you have a certain set of rights, but you can go to court, you can get a statutory relief for each occurrence of retaliation, and it will pay for reasonable attorney's fees. This doesn't take away the necessity in fighting these battles for people to have to work with attorneys. Unfortunately, our court system isn't designed very well for people to advocate for themselves. But it does certainly create a lot more certainty about what people's rights are, and really creates a standard for what you need to do and what you need to prove, and creates a lot more clarity than we've seen in the past.
Representative Kozlowski.
Yeah, I just want to say thank you so much for bringing forward this bill, and it's really going to set us on a good footing in that floor that you're talking about. So thank you.
Representative Dotseth.
Thank you, Chair Howard, Representative. I don't want this to be taken wrong. I think I understand the heart behind this bill and your intent behind it. But I just want to ask, not all organizers are the same as well. I think you'd have to testify just like all landlords may not be the same as well as all organizers. And I think there's just a lot of things that can be modified and adjusted in this bill that would help enhance this. I guess I've got some concerns. If I've got a 85-year-old grandmother living in a facility and she's volatile and respects her privacy, and you get a knock on the door from a organizer, I just look at what could potentially go wrong at that type of situation. Or a single mother with 2 children, and someone knocking on the door, a stranger knocks on the door. I mean, it just really opens up a lot of volatility for a lot of different groups of people. And I think that's what we got to look at, the property rights of all people. And that's what we have to address. I think this needs to be fine-tuned a lot better before we get to the point that we want to get to. But I understand the hurt behind it. Thank you.
Representative Petersburg.
Thank you. Yeah, I guess I'm going to just piggyback a little bit on what Representative Nash said, and the reason why I have some concern just for consideration. It's one thing to have organizers within the same community, the same building there, because most people will at least know something of them and they can get that information of it. But unfortunately, we also have a society in which there are a lot of bad actors that are preying in on vulnerable people. And so when a bad actor who comes in to a situation where there's a lot of vulnerable people and promotes that they are going to organize and get people involved with that, and then decides to say, we need this much in order to be able to do the work, or whatever it might be, and people fund that, and then they get taken for those dollars. I'm wondering, would they not have some sort of claim back to the landlord because they allowed that person in to actually involve them? So the question about whether or not organizers are there for a good purpose is real as to what the need is for. How that comes about, I'm not sure. And maybe a background check isn't the correct way when the organizer's coming from outside the community, but it should give us some sort of pause to say, we don't want people to be victimized because the benefit of organizing is certainly there, but there's also some, I'm hearing all the time of people that are taken from fraud, from online, people that are talking about money that they invested and so forth. And so there's some concern there. What level of importance, I think, is still needs to be addressed, but that's a concern that we have, and that's for whatever it's worth. Thank you.
Vice Chair Agbaje.
Thank you, Mr. Chair. This question is probably better suited toward Ms. Kaplan, and it's probably going to be a series of questions. But in most leases and property managers, they usually allow tenants to have guests, correct? And then they usually also allow, oftentimes, commercial sellers, especially people doing table promotions. The restaurant next door is doing a promotion. There might be people who are distributing coupons within buildings. That happens, is that correct?
Ms. Kaplan?
Thank you, Mr. Chair. Sarah Abaje. Yeah, it can. I mean, sometimes they do, sometimes they don't. Sometimes they prohibit that, sometimes they don't. But they make choices about it, and so it's a little, can happen.
Right. And Mr. Chair, my other question too is most residential properties also have rules related to when cleaners come in and repair people and delivery people. And that usually is, to going back to one of the testifiers noted the language in 2.24, that usually is sometimes done with permission and then also structured in the time and place and manner in which your delivery person can come in. Is that correct?
Ms. Kaplan?
Mr. Chair, Representative Abaje, yes, that's correct.
Vice Chair?
Mr. Chair, so yes, and then the last group too that often comes into apartment buildings, which many of us know are politicians who come in and try to organize to get people to come out to events like precinct caucuses. So I'm thinking that if someone is a tenant organizer and they come from an organization that hopefully has hired them and done their best practices regarding employment law, that if a tenant invites that organizer, they would then also fall under the same rules that govern guests, visitors, repair people. And if something bad were to happen, which we don't want, but if something bad were to happen, the landlord has a remedy that they can pursue against the tenant and or that organizer themselves. Is that correct?
Ms. Kaplan?
Thank you, Mr. Chair. Thank you, Representative Abaje. Yes, so they would not be different than other guests. There wouldn't be any particular onus placed on the landlord. It would be if somebody is engaging in illegal or inappropriate activity or they're trying to commit fraud, those are things that they would be, like, that person committing those acts would be responsible for.
Vice Chair Baje?
Mr. Chair, so I think finally I'll just note that we have structures in place in our landlord-tenant law and our leases that already try to prevent bad actors from coming into apartment buildings. And I think also too, from an organizing perspective, I think as you noted earlier, if someone does not want to participate in the organizing, they have the right to say no, the same way that they say no to many of us when they don't want to talk to us when we're trying to entice them. And so I think, this is an opportunity for residents in a building to be able to see if there is an appetite to form a tenants association. If there is not, then I think those tenants would push back and say, you know what, this is not something that we want. We don't want you coming around and asking us about this anymore. And if you do, we would take the appropriate action. And so I see this bill as a way for tenants to have a voice, whether they want to organize and work together to enhance their living situation. But if they're fine with their current living situation, or they don't feel the need, or they may be too scared to update it, they don't have to. And I'm not sure wanting enhanced security measures for a non-resident when I've listed about 10 types of non-residents who come into our buildings every day. And as a renter, I can tell you I see a ton of people that probably should not be in my building. But, I think if I was really worried, I would be able to go to my landlord and say, you might want to check out this person. So thank you for bringing this bill forward. And I appreciate talking about this issue because I do think it's important so people can know what the safety concerns are.
Representative Myers?
Thank you, Chair, and thank you, Representative Perez-Vega and Ms. Kaplan for testifying. I'm just looking for a little bit of clarification. Lines 2.4 and 2.5 talk about issues related to living environment, which then discusses terms and conditions of their tenancy and also activities related to housing and development. I'm just looking for clarification or examples. I can see the living environment or living conditions, but when you start talking about terms and conditions, a lot of times that's disclosed early on. And so I'm just wondering from this language, what does this cover and what does it not cover?
Representative Perez-Vega or Ms. Kaplan?
Thank you, Mr. Chair. Thank you, Representative. So this is pretty expansive in the sense of people can organize around any issue related to their tenancy that they feel like they want to organize around. Once again, it doesn't obligate the landlord to respond in any particular way. Like if it's a violation of laws or specific rights, they should remedy those. But for example, people have organized in buildings because everybody in the building received a very large rent increase, right? And so they came together, they had discussions about it, and they made proposals to the landlord saying, hey, this rent increase is something we can't actually afford. And so it's just protecting their rights to work together to say that. It's not saying that the landlord has to respond in any particular way about that, right? Also, rule changes is another one. Sometimes the rules in a lease will change because, you have your lease, then your lease will come up for renewal, and maybe they'll make some changes to it. That's another instance where people are organizing around the terms of the tenancy, where they're like, you know what? To us, you might not be understanding, but this doesn't seem fair, or it's taking away a right that's really important to us. And so we just want to be able to tell you that and engage in discussion about that, and that our right to have a conversation with each other is protected. And we can do that, and we can't be retaliated against for working together.
Representative Myers.
Yeah, thank you for that. I mean, I think what you just said to me was, you can get together for any reason. If everybody's got the same rent, it doesn't change, then, they could get together as a group and have no limitation on putting pressure on a landlord of any sort. I was trying to look to see if there was any limitations, because to me, the living environment, the terms and conditions, I mean, some of this stuff is predetermined from a lease. So I think that was clarifying for me.
Representative Cha.
Ms. Kaplan, question for you. Is there a background check requirement for like contractors and maintenance people who come to rental properties to do repairs?
Ms. Kaplan.
Thank you, Representative Howard, Representative Hussein, or Cha, sorry. I'm like looking at the name in front of me. I know who you are. Representative Cha. No, there is not a background check for people to come in and do repairs on the property.
Representative Shaw.
Yeah, the reason why I bring up this issue because I'm a father of 3 daughters, right? I've been a renter before, and not all landlords are the same, right? Some landlord hire contractors that may be questionable, but that's just one of my concerns when we talk about access to my rental property or so forth. That when someone like myself has a father and having someone in my home. Doesn't make me feel comfortable if they also don't have background checks, right, on contractors who are coming to the property. So that's my concern. Thank you.
Lee Johnson.
Chair Howard, Representative Pres Vega. Quick question for you. If a organizer is allowed in, no background checks, and they do something, who's liable?
Ms. Kaplan.
Thank you, Representative Howard. Thank you, Representative Johnson. So somebody who comes onto the property and does something wrong or illegal, they are responsible for their own acts. If they are a guest of somebody, then the tenant is also responsible for their own guests.
Lee Johnson.
Chair Howard, I have concerns with the liability issue on this. I'm going to take an example from a incident that happened to a very close relative of my wife. She was actually killed in an apartment building by a person that was living there, not on the lease. Management didn't know they were there. Very extensive criminal history, violent history. was given a key and access to the building by the renter, it was the management company that was held liable. Not the person who let them live there. It was the management company and the owners of the building. This opens up huge liability to the property management and the owners of the building. Should something happen, I hope it never does. Now, you talked about the person to come to fix the toilet. They're hired by the management company, but guess what? The owner of that company is liable for the actions of that person. The organizer isn't hired by a company. So it'll turn around with the deep pockets. It's going to be the management company that's going to be sued should something happen. But this bill gives them no rights to do any checks on the person, any background, history. Anybody could come in and say they're going to organize, and they'd have to be let in. There needs to be some checks and balances. I understand why you want to do something like this with the issues that Marion had. And Marion, I hope if the city councils and the city officials aren't doing anything, go to the county prosecutor or the city prosecutor, because what that landlord has done is either a gross misdemeanor or a misdemeanor in the 504 statutes already. And if they refuse to do something, ask them why they're refusing to enforce the laws. Because the retaliation is already against the law. So I do have a few problems with this for the liability issues and the safety of the tenants in that building. And with that, I'm going to request a roll call.
Representative Lee Johnson requests a roll call on the bill. Any other comments? Otherwise, I'll go to Representative Perez Vega for a response or any final comments on the bill.
Thank you, Mr. Chair, members of the committee. I want to address as a renter, I actually had something happen to me about 2 weeks ago in my property where someone stole my bicycle. They walked in through the surveillance. We filed a police report with our management, who was great, helpful, to make sure that it wasn't a guess of a resident. Surveillance came, our officers from the SPPD came, filed the report, were able to catch the folks that did it just based off of the surveillance. And that person was not a guest of anyone. And it was just a matter of law. Somebody did something bad, and the law took care of it, right? I didn't get my bag back, but I'm glad that everyone's safe. And it's unfortunate what happened, Representative Johnson, to your friend. However, when I think about Marion and I think about the testifiers who came here today, who may not have known about the accessibility of those rights, when we seek the folks that have been advocating for this law, the systemic injustices of even civic engagement, to understand that what may be basic for someone isn't for a lot, in particular as to why we are presenting this 2704. It's important to recognize that there's bad things happening in certain places all the time. But if you don't communicate and know your neighbors, how are you even to address that? This is an opportunity to communicate to keep things safe around residential properties. And I also like to thank Vice Chair Abaje for your statements, especially as we're getting ready into a couple days away from caucusing. And me having a district that has a lot of apartments, that we know our rights, that as someone running in for office, that we have to have a resident with us the entire time as we knock through those doors. You have to have a resident this entire time that you'd like to organize. That's why we're here to present this, is to say, we want to make sure that there's safety for the residents, that there's safety for the property, and that there's safety for the management. It's clear that this isn't about allowing protests. I didn't see that language in here either. That was me. That was not in that section. it's clear that it's about making sure that everyone who's underneath a roof of twoplex or more has the ability to congregate, to celebrate, to recognize the pits and the peaks of what's happening, and to maybe even get civically engaged in opportunities that have never been a part of their culture, their community, expectations. And I look at this as democracy here. I look at this as a value for our residents in this state of Minnesota to be participating in avenues to keep our communities safe. Thank you.
With that, Ms. Erdahl will take the roll. Oh, excuse me, sorry. I wanted to clarify that what we're voting on, Representative Perez Vega is renewing the motion that House File 2704 as amended be recommended to be referred to the Judiciary, Finance, and Civil Law Committee. Now we can move on to the roll.
Chair Howard.
Chair votes aye.
Vice Chair Agbaje.
Aye.
Lee Johnson.
No.
Representative Cha.
Aye.
Representative Datsas.
No.
Representative Hassan.
Aye.
Representative Kozlowski.
Aye.
Representative Myers.
Nay.
Representative Nash.
No.
Representative Norris.
Aye.
Representative Perez Vega.
Aye.
Representative Petersburg.
No.
With a vote of 7 to 5, the motion prevails and House File 2704 is on its way. Thank you.